Speaking of things that should be obvious even to complete morons, a court had to explain to cops that having perfectly legal items in someone's possession isn't evidence of anything. Really, how are cops not the worst? Still, it's nice to know that sometimes the courts don't just kowtow to whatever the drug warriors want, considering that they'll just blindly accept, "I smelled marijuana," as a justification for a warrantless search. No matter how many times it's shown there was no marijuana anywhere in the vicinity, it's nice to see there are sometimes limits. In this case, it was Chief Judge Martin Reidinger in the case of U.S. versus $13,205.54 in U.S. currency seized from Rakeem Franklin on August 21, 2018 in Rutherford County, North Carolina. That's the name of the case. Yes, it's yet another asset forfeiture case. After an officer smelled marijuana and seized a bunch of cash from a car belonging to Rakeem Franklin, they noticed that he was also an owner of several guns, which they said, quote, have long been recognized as being tools of the drug trade. So, in other words, because drug dealers use guns, anyone who has guns must be a drug dealer. Well, do drug dealers eat bread too? Maybe everyone who eats bread is a drug dealer. But wait a minute. Criminals use guns, so anyone who uses a gun must be a criminal. Cops use guns, therefore... Hey, I think we may be onto something here. Let's see how far we can go with this. Criminals steal money, and they claim it was legal. Cops steal money and claim it was legal, therefore... How many iterations of this can we do? Criminals murder people and claim it was self-defense. You get the idea. Franklin had the money in his car because he was on his way to a bank in Forest City to deposit the money in his bank and to pay off a car loan. On the way, he stopped by a restaurant to pick up a takeout order. Deputy Wilmer Chavez Perez saw Franklin's white Honda Accord and thought the tinted windows just had to mean he's a drug dealer. He activated his lights and pulled him over, and that was when Chavez pulled the old, "I smell marijuana" warrant substitute. After searching the car, they found loose bits of marijuana on the floorboards, and Franklin claimed that it was legal hemp. Chavez conceded there was no difference in the smell, and not even a drug dog could tell the difference. Chavez didn't even bother collecting the bits of marijuana as evidence. He just took the cash. There was also a 9mm pistol and a knife in the car, and they arrested him on weapons charges. He was not charged with violating any state or federal drug laws. Oh, and they also did the bit where they had a drug dog sniff the cash. They also used his invocation of the Fifth Amendment as evidence of suspicion. These cops are scumbags. Thankfully, Judge Reininger found in Franklin's favor and ordered the money to be returned. In the process, he noted regarding the firearms claim, quote, "It is undisputed, however, that Mr. Franklin owned these firearms legally. He is not a convicted felon or an otherwise prohibited person. Further, none of Mr. Franklin's firearms were subject to forfeiture by the government. The government has not presented any evidence from which this court could reasonably conclude that these firearms were owned for the purpose of furthering any criminal activity. For the government to suggest that a citizen's mere possession of firearms implicates that person in illicit drug trafficking is to strain credulity. The government's argument presents some Second Amendment considerations that counsel has apparently not considered." By the way, the only reason they knew about the other firearms is because Franklin had them legally, which is something that drug dealers don't often do. And if you've ever wondered why it is that people say a gun registry would be abused by government agents, well, here's yet another example.